Mandatory sentencing sucks, and that's what we have here in Arizona. And what's worse is that you're just expected to know what's going on. You walk into a room, someone hands you a sheet like this that's got highlighted portions on it and says, well, this is a really great option, this is what you should take, and doesn't even take the time to explain that to you in the 5 minutes that you have that conversation. I'm Ryan Cummings with the R&R Law Group, and today we're going to take a look at the mandatory sentencing guidelines that we have here in Arizona. What that means is that when you see a board, something like this, is it means that these are the guidelines that are given to our judges. These are what they're able to do and what they have to sentence you to if you're convicted of a felony. Here's a better look at it. This is the chart that they use. As we look, it's in two separate categories. So up here at the top, this is the portion that if you've never been sentenced for a felony before, that's the category that you'll fall under. That means that probation is eligible for every one of those offenses. Now, there are a few exceptions: dangerous offenses, dangerous crimes against children. If it's a drug offense over the statutory threshold, that even if it's your first offense, it can still take you out of that sentencing statute. But generally speaking, if you've never been convicted of a felony before, you'll fall in within one of these ranges. Okay. As we get a little bit farther down, and we'll dive deeper into this as we go through this video, but you'll see this is still Category 1. Those are the exact same sentences there that are set forth as up here. But what that is that means it's a repetitive offense. That means that you've already been sentenced for a felony once, but you fall under Category 1 as a repetitive offender. And then it goes to Category 2, and then it goes to Category 3, repetitive offenses. So as we take a look at this, you'll see that you've got a couple different terms. You know, there's the MIT with the asterisk next to it, MIN, P, max, and aggravated. All right, and we want to talk about what those terms mean. All right, so the presumptive term, that's right in the middle. That's where the judge will start when you go to sentencing. So the presumptive term, that's the very, very middle. So for a Class 2 felony, that's 5 years as a first-time offender. What happens then is that the judge can consider mitigating factors. Those are factors that weigh in your interest. And then the judge can consider aggravating factors. Those are things that the state is bringing to the judge to say, hey, we should sentence this person more severely than somebody else. Depending upon how many mitigating factors there are and how many aggravating factors there are, that means the judge is either going to go up in your sentence or is going to go down in your sentence. So as we look at the chart again, you can see, the mitigating sentences are much less than the aggravating sentences. You'll also see the class of felonies. So those are the different classes of felonies that we have here in Arizona: 2, 3, 4, 5, and 6. Class 6 felonies, those are punished less severely than Class 2 felonies. There are some Class 1 felonies, but those are things like murder, and those aren't set out by statute. Those have their own governing statutes there, so they're not covered within this that we're looking at today. So as we look then, and we get into the chart and we start looking at some of the other felonies that we have, or we get into the different categories: Category 1, Category 2, Category 3. All right. As you look and you see Category 2, the sentences jump up quite a bit further than they do in Category 1. So for instance, if we look at the Class 4 felony, the presumptive sentence in Category 1 is 2.5. It almost doubles into Category 2 to 4.5. And then as you jump up into Category 3, it more than doubles, and your presumptive term is 10 years. So why is this important? Well, this is important because this is where you're determined to fall depending upon how many prior felonies you get, or what the state is going to allege. If the state alleges all of those prior felony convictions, or there's issues with the state's case, maybe then they'll take away those felonies in order to work out some sort of plea agreement. That's the big problem that we have, is that all this power lies in the prosecutor's hands as to whether or not they're going to allege that. That's why it's important to find those legal issues with the case so that you have a better hand negotiating, so that you don't walk into a courtroom, get this thrust in front of you, and somebody says, well, you should take a deal for 9.5 years because that's a lot better than 16 if you go to trial and lose. So what bumps us up in those categories? What makes us go from a Category 1 to a Category 1 repetitive offender, or a Category 2 or a Category 3? And those are determined by our historical prior felony convictions. All right, so if you have a historical prior felony conviction, as we mentioned before, one felony conviction but not historical, that's going to put you in that Category 1 repetitive offender range. So as we look, that's almost the same as we saw up here in the probation area, but it's going to be down here. Over here is the Category 1. And that means that you've got one prior felony conviction, but it is not a historical felony conviction. All right? Category 2 means that you have at least one historical prior felony conviction, and Category 3 means that you've got 2 or more prior felony convictions that are historical, and that's what makes you up in that top range. So historical prior felony convictions. Number 1 is going to be one that mandates a term in the Department of Corrections. So if you got sentenced to prison, or prison was a mandatory sentence based upon your sentencing scheme when you went to trial and lost, then that means that that's going to be a forever prior. That means that it's always going to count as a historical prior felony conviction, whether it happened 5 years ago, it happened 10 years ago, it happened 20 years ago. The next one, as we get up there, that's going to be a dangerous offense. So anything that's alleged to be a dangerous offense, if you go to trial and lose on a dangerous offense, that's also something that's going to be prison mandatory. So that's also then going to be forever prior, always going to be historical prior. Next, we've got illegal control of an enterprise. Again, that's another felony conviction within the state of Arizona. If you've been convicted of that, that can be a forever prior. Now, one that we do see quite a bit is an aggravated DUI. So that's number 4, Ag DUI. That's aggravated DUI. That is a basic DUI that, for whichever reasons, it has been aggravated. There's a couple different ways that you can get an aggravated DUI, but it's important to note that that is a forever prior. That means that if you got an Ag DUI when you were 21 and you're now 50, then it doesn't matter that that was 29 years ago. That counts, and you're going to automatically be placed up into that higher category, and you're going to be in Category 2 rather than as a Category 1 repetitive offender. All right. The next one, DCAC, that means dangerous crimes against children. That, again, has its own sentencing provisions if you're convicted of a crime that is considered dangerous crime against children, but that also will be a forever prior. The other one that we deal with commonly is determining whether or not the felonies fell within a certain time frame. That is going to be indicative upon whether or not it's going to be historical prior or not. So as you can see, there's 2 different ranges. There's a Class 2 or a Class 3 felony. If those occurred within the last 10 years, then that's going to be considered a historical prior felony conviction. If it's a Class 4, 5, or 6 felony conviction within the last 5 years, then that's also going to be considered a historical prior felony conviction. Now, as we've got down here with the asterisk, time in custody doesn't count. So what that means is that if you went to the Department of Corrections, you went to prison on a prior felony conviction, that means that a Class 4, 5, or 6, that 5 years doesn't count or doesn't start counting until you're out of custody. So, if you spent 2 years in 2010 and you didn't get released until 2012, that 5 years then wouldn't be up until 2017, or that 10 years wouldn't be up until 2022. So that's where you've got to look at those, and that's how those timelines get calculated. Lastly, down here, what we have is your 3rd or more prior felony conviction. So what happens is once you get to a 3rd prior or a 3rd felony conviction, that then is going to be a forever prior. You're always going to have that as a historical prior felony conviction. So what that means is that once you get up into that range, you're almost always going to be considered a Category 3 offender. And that's the highest level offense that we get. Again, as we talked about that Class 4 felony, the presumptive term on a Class 4 felony is 10 years. And what's a Class 4 felony? Some aggravated assaults are. 3 of the 4 different aggravated DUIs, those are all Class 4 felonies. So, it could, wind up being a very, cut and dry case as a Class 4 felony, but because you've fallen within some of these categories, you're walking into a courtroom and someone's telling you that you need to take a 7-year plea deal and you need to go to prison for 7 years, because if you go to trial and lose, then you're going to get 10 years, and that's what makes it a good deal. That's why a statutory sentencing is so difficult to overcome. And that's why, the prosecutors are the ones that have the most power in the courtroom. A lot of questions that we get are, well, can't the judge just do whatever he or she wants? Well, no, they can't, because they're set out by these statutes, and they have to abide by those statutes. Otherwise, it's considered an illegal sentence. So, oftentimes, we'll see that, and someone will say, well, we'll just go to sentencing and ask the judge to give him probation. And, I've listened to judges, tell people, I would love to give you probation, or, I understand where you're coming from, but probation is not an option at this point in time. The ACLU actually did a study and said, the most powerful people within the justice system is your elected county attorney or your elected prosecutor. Again, why? Because they're the ones that are setting forth, what the plea agreements are, what their guidelines are, and the different areas in which they're able to send people to prison or not. And that's why it's really important to have a good defense attorney on your side, because you want to be able to argue all of those things, in negotiating with the state, negotiating with the prosecutor, because everything that's contained within your plea agreement, that's the most important information. Because once it comes time for sentencing, the judge is left with very, very little discretion. And if you don't have everything worked out before you get to sentencing, then, then that's a problem. And to be honest, things are going to be worked out one way or another before you get to sentencing. And, if you don't have somebody who's fighting on your side to find those issues with your case so that you can negotiate down and get rid of some of your prior felony convictions or get you a lesser charge, then you're going to be stuck with something that's higher, and you're going to go to sentencing, and that judge is going to say, because of the statutes or because of where you fall in these ranges, I have to sentence you to 4.5 years in the Department of Corrections. Okay? That's why it's important to get somebody to fight on your side. That's why you need to call us at the R&R Law Group, because we're going to be there to walk you through every step of the way and fight for that best outcome that you can get. If you have any questions, feel free to email them over to us. Thanks for watching.